Let's talk IP. Let's talk IP. Let's talk IP. Written by Saltanat.
Hello and welcome to Let's Talk IP, the podcast where we decode intellectual property and bring you interesting conversations with IPR experts, shaping and driving the future of innovations and crafting innovation landscape. I'm your host Svetlana, and today's episode is specifically designed, drafted, curated, or crafted for IPR professionals, specifically patent or patent professionals involved or engaged in patent drafting. In today's guest episode, we are super thrilled or super excited to feature a very special guest. I call her Master of Drafting. Very diligent, very focused, and very, very detail oriented. So, today we'll get to know, or we are going to know, all the important do's and don'ts of patent drafting from her. Joining us is Saltanat Jazbi, founder and director of Jazel IP Consultants, an engineer and a lawyer deeply engaged in the field of intellectual property rights, specifically patents, with hands on experience in patent drafting, prosecution, IPR strategies. Saltanat brings a very fresh and unique perspective on patents. Plus, we'll also get to know her insights on patent or IPR ecosystem in India. Before we start, we would like to re-emphasize or restate that today's episode is specifically designed, drafted, curated, or crafted for patent professionals involved or engaged in patent drafting. We would also like to state a disclaimer here that we are not teaching drafting. We are assuming that the audience is well versed with the basics, the basic flow, the structure, the basic rules and laws of patent and or specification and or claim drafting. The weightage and role or preamble of claim, the antecedent basis, the difference between invention, innovation and discovery. Most welcome, Saltanat. We are super thrilled to have you here today on our podcast.
Thank you, Svetlana. It's my pleasure to be here. Thank you for inviting me. And you are doing a commendable job of starting this podcast,
Thank
which
you.
is related to specifically related to patents and IPR. So I'm thrilled to come here and looking forward to our discussion.
Yes, definitely. I am also looking forward to it. Saltanat, let's start with the most important section. So I call it the real battlefield or the real battleground. The section that is examined by the PTO examiners, the section that defines the scope of the invention, the section that defines the boundary of protection, the section upon which you get the exclusive rights. I am talking about the claim
Claims,
section.
yeah.
That is the most important section. So let's start with claim section. So while drafting, how do you ensure or assure, or rather, how do you consciously draw a line between being broad enough so that you get the strongest possible protection, and it is difficult to work around the invention, and the invention is relevant for the coming 10-15 years, and narrow enough so that it is easier to overcome the PTO examiner rejection. So, in one sentence, I can ask, how do you outsmart both the competitors and the PTO examiners at the same time?
Yeah. So, like you said, claims are the important part of any patent specification.
Yes.
Because the claims are going to examine the read by the examiners
exam.
in various jurisdictions wherever you file your patent applications. So the claims are very important. So you have to put all your mind and do all your brainstorming. You have to discuss with the inventors. First of all, you have to be very thorough with the invention. You have to understand what the invention is, the concept the inventor has in their mind must be conveyed to your mind.
Yes,
And
absolutely.
you have to apply your skills of drafting the claims, keeping in mind both the prosecution part and litigation part to make it robust and make it workable for the clients.
Yes.
So it's not only writing sentences. It's a legal document. You're preparing a legal document which is going to be read by examiners first hand will be read by the examiner, and then it will come to public, and then at a later stage it will decide whether your competitors are able to design around your product or process,
Yes.
or whatever. So you have to be very careful. So it's always good, like if I talk about myself, in my opinion, it's always good to have a broad claim first, then narrow it down in the dependent claims. So you think of your invention, your client discusses about it, you read about it, the background and everything. You do a little more research about it, the prior arts, and then you draw the differences, what existing prior art was doing, and what your client wants to protect. So that line, when you understand it thoroughly, then you are able to draft a claim broadly. It should not be very broad, so that it should not be very narrow, that it is very easy to design around. Like
yes.
you should not provide specific details, like if the thickness is 3 mm, you should not define it over there.
Yes.
You should always give a range in the specification, and you should always play with words.
Yeah.
So that is how claim should be drafted. Many people think that, okay, primary claim or independent claim I've drafted, it's okay, I can put anything in the dependent claims. No. Dependent claims are as important as the independent claim.
Yes.
Because each claim should be novel.
Yes.
Although it is dependent on the primary claim, so it becomes very easy for us during the prosecution time.
Yes.
But sometimes they play a very crucial role during the prosecution. It helps us to narrow down the broadest claim, and it helps us to win the prosecution part, like win the patent. So the important features should be covered in
the dependent.
So fallback positions should be covered by the dependent claims, and the independent claim should cover the broadest feature. Again, I would say it depends upon case to case. You cannot put all cases, you cannot generalize the drafting of claims. So depending upon your case, and depending upon the cases of your inventions, like if it is software invention or mechanical, or if it is only a mechanical part or small invention, like a safety pin, for example. So you cannot keep very broadest claim. What will you claim? Because the product itself is very small or very simple claim, but still it is an invention, right? So in that case, you will have to be very specific, so that you
can claim
claim that feature which is novel or inventive. But it is not it does not go with every invention. So you have to apply your mind. Of course, when a drafter drafts the claim, they are able to understand, they are able to focus on what features are important to cover first, and then in the dependent claims. But
I was about to ask this, that you generally prefer this strategy of drafting, start with broad claims and then fight it out at the time of prosecution and then narrow it down, rather than playing it safe and starting with narrow claim and then later on broadening it using continuations or divisional. Because many attorney, they follow second strategy, many prefer the first strategy. So Saltanat, for our professionals and audience, what advice will you give? What parameters or what scenarios they should consider on deciding on whether to start with broad claims or to start or go ahead with narrow claims?
So as I said, it's always good to go with the broadest claim, because you
get the best possible protection.
And it is difficult to design around the broadest claim. So it keeps your competitors aside. But in some scenarios, when the product is small invention or it has limited features which cannot be drafted broadly, and it had to be specific. At that moment, it is we who decide that it should be a narrower claim rather than going very broad.
Okay, like the patent of addition also, like little enhancement
Yeah.
is there or little additional feature is
Yes,
there, then you
yes.
have to draft.
Very specific
yes.
claim, because that is
Absolutely.
the addition,
Absolutely.
additional feature which the client wants to. They have developed it later at a later stage, but still want to claim the priority of
Yes.
the earlier one, and they don't want to go into the examination
Totally.
of the small feature.
Got it.
And sometimes the when the product is ready to launch and they have to they are relying on that feature, then we decide that the claim should be narrower, because there are buyers in the market to buy that patent, and they rely on that feature. So when conditions like these comes in the picture, then it is preferable to claim the specific features rather than going very broad, so that the investors are saying, okay, what you are showing me a different product, and but your claim is a different
Yes.
talking about
Got
a
it.
different thing.
Yes.
So in those cases, yes, it is good that you claim the specific features, go a little narrow, and later on, when
Decide
you improve
on-
the product, you may go with another patent specification with improvement, which is having a novel inventive feature. Then you claim it very broadly, and so it's a continuous process. It's not that you develop a product and there is only one patent and you sit. It gives you motivation. It gives the inventors motivation to do more research, do more R&D, and come up with new inventions. So it's always rewarding. The patent is rewarding. Even when I've seen clients, even when their patent is published, they are very happy about it. That they want to see how it looks, how their name is displayed, and they proudly say that their patent application is pending. So it's always rewarding. It's always, we should promote the even small inventors. Inventions are not like they can be very big invention, complex invention. They can be small inventions also. So it's very rewarding. It's very encouraging. Once
So if inventors are coming to you, they have developed prototype and they come to you, then that time you prefer going with broader or narrower claims?
the broader also, and we put the future aspects also,
Okay.
which any product or any process might have a certain feature which they are not ready to develop it now, but they might add it later. So we ask questions with the inventors that how they are going to develop it further, or because you are a patent attorney is
Attorney,
experienced
yes.
so much, they
Yes.
have to think like inventors.
Yes.
So they have to add new features in the claims, so that it covers the extra features also, which at this moment the inventor is not able to think.
Yeah, so it is relevant.
Yeah.
It has its relevance for the coming 10, 15.
Coming 10-15 years.
So, Saltanat, like we were discussing about AI and software based inventions, exactly same question with reference to software and AI based inventions, where inventions are evolving like at crazy fast speed. So, there also.
Yes, there also, because although it is changing, but we have to think for the coming 10-15 years.
Yeah.
The patent itself will take 2-3 years or 4 years to get a grant.
Yes.
And so you have to at least think beyond 5 years.
Yes.
So the claim should be broad enough to include all those features.
So that it is difficult to
you
work
should not
around.
go very specific, because if the technology changes, your claim is outdated.
Yes.
So it is better to describe all those features, all the details of the AI in this specification, but keep your claim broad enough to and think of the features which might happen in the future.
Yeah. Okay.
Keep on researching, keep on follow the trend, see what the trend was
Got
back
it.
like 5 to 10 years ago. What was the trend?
Got it.
How it is being developed? Understand the pattern and then implement it in the claims. Yeah.
Got it. So, Saltanat, also, can you suggest some subtle mistakes that go unnoticed at the time of drafting or even at time of filing or prosecution, but later on at the time of post-prosecution or at the time of litigation,
Yeah.
those mistakes proves to be really fatal or
yeah.
detrimental for the patent.
Yeah.
So, can you state some?
So there is a term called patent profanity.
Okay.
Profanity is the words which you should not use. Okay, during our conversation also, if you are talking to anyone, we talk in a civilized manner. We don't use
Yeah.
bad terms. So there are some bad terms for a patent drafter should understand that they should not use it in the claims. For example, maximum, minimum, about. So these are the words. These are considered to be vague. They are not definite words. They are not providing you the inventions to be definitive. So you will attract rejections from the patent examiners. Either you be silent on it, or you define it in the specification in a proper manner, but don't use vague terms like mostly or usually or preferably. Okay, so it has to be specific. So sometimes the draft is very good, the invention is very good, but these terms, when they are used,
proves to be
they
fatal
proves to
for-
be like fatal for the patent specification. They weaken the case, they weaken the patent draft. So these terms should be avoided by a drafter in
So
the claims.
these terms are usually overlooked by the examiner, or we get rejection at the time of prosecution.
So sometimes, for example, in the USPTO, you get 112 rejection. The claim would be considered as indefinitive. Like you have not defined a specific
Correct.
term.
Correct.
And you have to be consistent. If you have defined a certain term in a claim, stick to that. Don't use 2 or 3 terms for a simple component or similar component. If you're calling a server, then call it a server. If you're calling a cloud server, call it a cloud server. And
Or
then
at
define the cloud server.
At one place, you can define that these are
Yes,
the
yes.
alternative
That
terms, but
definitions-
you have to be
yes.
consistent throughout the specification with one term only.
Correct. So like how we put glossary in a book or in a technical specification, likewise it is always advisable to define your what terms you are using in your patent specification, so that it becomes very clear for the reader, for the examiner to understand the invention. For example, I can use database for a certain purpose. I can just use it to store certain data. In some invention, it might also act as a smart data server, which is automatically deleting some old data and making space for new data. So that is working as a smart and intelligent database, which is having some kind of sensor or programming or something in that device. So if you will just call it a database, it will not enhance its feature.
Yes.
It will become very obvious. Okay, this device is already known, and you are just using this device for the purpose for
Of
what it is
storing
already
data.
known.
Yeah.
But when you connect it to certain smart node or smart intelligent circuit or programming, and when it is programmed to do some auto deletions or auto modifications, then you are enhancing the previous technology. I'm just giving you this example.
It's a good
Yeah,
example.
yeah.
It's a very good
Yeah.
example.
So you have to define
can we
that.
also come up with our own term for it, and then we can define it in the specification?
Yes,
that
we
this
can coin
term
our
stand-
terms, like
Yeah.
we can coin our terms like smart database, or we can cloud database. And then whatever specific function that device or
Is-
component is doing,
Uh-huh.
you should specify in that
Yeah.
specification, in the description
So that
part.
the name itself is descriptive enough
yeah,
to.
yeah. So it is not hanging in the claims like why you have used certain terms. It has to be defined. It has to be very clear.
Saltanat, what's your strategy when you are drafting for multiple jurisdictions, like multiple international jurisdictions?
Yeah, sometimes we have to cover multiple countries,
Right.
and each country will have their different laws.
Correct.
So, what I do, I keep in mind the PCT application, the articles, and then keeping in mind those articles of WIPO and PCT. I draft a PCT application, even though if it is going to be filed in India. So once you file the PCT application, that is examined, and if that report is positive, if the prior art is not very strong, or if they do not consider any prior art, relevant prior art, then you can request other officers also to consider this report. The member country, although they are not bound to go with that report, but still you have an upper hand, and you get a chance to amend the claims in the PCT application as well. So what you have to do, you should think of jurisdictions like PCT, EP, US, so that the broadest area in EP is covered, and it is also acceptable in because I'm sure you're also aware that EP really are they do very strict examination, and we Indians also follow the same doctrine, that we have to be very strict. We unlike US, we do not go for software applications, software patent applications. So it is advisable to draft a PCT application, keeping in mind even if you are filing in India, and then keeping in mind the EP jurisdiction, keeping in mind the US jurisdictions, what kind of rejections they could get
UK.
during the office action. UK as well, yeah. For example, if in the USA, they are very particular about antecedents and
Yes.
the support in this specification. And if there is a 101 rejection, you have to prove that it is technically advanced, it is just not an abstract idea. So those kind of rejections can be overcome at the drafting stage. If you're not thinking in that aspect, if you're just drafting, if you're just putting in papers whatever the invention is, and you're not keeping a thought of what rejections you could receive, then you're not doing your job perfectly.
Yes, so
Yeah.
actually a good drafter has to be
Has
a good
to
prosecutor.
think, yeah.
as
First,
well,
yes. So first, a good drafter should think about the rejections.
From
I'm
prosecution point of
writing this claim, whether it will attract 112A rejection, whether it will attract 101 rejection. Have I done my research correctly? Have I done my prior art searches correctly? So even if the prior art searches are done by the inventors, a drafter should do a prior art search.
Yeah,
To
that's a
at
must.
least, yes,
Yeah.
at least the prior art references given by the inventors should be well read, so that you are not close to that, and it is not acting as a hindrance during the prosecution.
Yes,
Yeah.
absolutely.
Yeah.
Yeah. So, Saltanat, one golden rule for drafters.
Golden rule. Yeah, like
With respect to claim and specification drafting, one golden rule that you would like to.
understand the solution, what solution the invention is providing, and that should be captured the essence of the invention should be captured in the claim. If it is a mechanical claim, you have written your first claim. By reading that claim, the picture of that product should come in your mind, in the reader's mind. Obviously, you have drafted, you have seen the product, so a drafter would know. But when the examiner is reading, he should be able to understand by reading your claim, okay, this is talking about
Okay.
this. Yeah.
So your golden rule is start with picture claim.
Picture
We
claim,
call
correct.
it, yes.
Yeah.
Okay.
Do not use like profanity terms. Do not use vague terms. Like absolutely or without or maximum or
And
minimum.
understand
Yeah.
the in and out of
In
the
and
invent-
out of the invention.
Yes.
Talk to the inventors, understand, do your own research. Just don't rely on what inventor has given to you.
Yes, absolutely.
Yes. You have to put your own ideas. You have to
You have
act
to
like
become
inventors. You
inventor.
have to
Yes.
become inventor. You
Yes.
have to act
Yes.
like inventor.
So you have to act like attorney and inventor.
Attorney and inventor and
and
prosecutor
and
and
everything.
everything.
Yes, that is real, like
Yes.
3-4 good points that you have given. So first to understand the in and out of the invention, and not to go too vague with the
Correct.
terms.
Correct.
So these are good points.
Yes.
Okay, and Saltanat, have you personally witnessed any such case, or you know of any such case where brilliant invention failed because of poor drafting, or poor claims, or bad attorney, rather I will say, and not so good invention succeeded as in generated lot of revenue with strong claims because of good drafting style and good attorney. So if you know of any such case that you would like to share with the audience.
Yeah. One case is coming to my mind.
Uh-huh.
It came to me during the FAR stage.
Okay.
FAR was also prepared, but the objections which were raised by the examiner, we were not able to convince the examiner that that the specification is already complying. So the examiner said that you have not given the technical specification. You have written claims, the invention is good. It was a kind of a table, a desk where for a child to study, which could be modified into some other object so that it is portable and you could carry it to any place. So that invention was good. It was usable. But the drafting was such that it lacked technical specification, like what kind of material was used, what is meant by heavy or what is meant by light. So when you say it is lighter to carry, what is meant by lighter?
So that was not drafted.
Yes, you have to
properly.
define what is
everything.
okay.
Yes.
Even if it is or you can also say that light enough for a child of this age to carry.
Then also
something
raise,
like this.
Then
yeah.
also they raise objections.
Yes.
How can you, like, it is very subjective.
Yes, it's very subjective. But yeah, that draft lacked technical specification.
And
they did not talk about the straps, what kind of straps they are using, how the weight is carried on the shoulder of a child, how it is helping. They just wrote that it helps the child to carry this thing. But it was all full of advantages. But how you are achieving that advantage was not written in the draft. So it was considered vague. It was considered
unenforceable.
Yeah,
everything.
Like not how anyone is going to manufacture it by reading your patent specification.
Correct.
So although the invention was good, we tried very hard. We were invited.
So you have witnessed this case.
Yes. We were invited for 2 hearings. The examiner gave us. He was kind enough to give us 2 chances, but again we could not because there was nothing in this specification. And as you know, whatever is written in this specification, we have to follow that. We have to keep in mind. We cannot add new matter.
Yeah, you cannot go beyond it.
We cannot go beyond the scope of invention.
Correct.
go beyond the
Yeah.
invention. Yeah.
So ideas was also not there, like the inventors' submission papers were not there.
The prior art was there, but it did not help because it was not. What happens that sometimes the prior art which is not close is given by the drafter. For example, a client comes to me and discuss about its product, his invention, and then what I do, okay, this I get a prior art which is not close. So if it is not close or if it is not relevant, why you are putting it in the background? Okay, you can mention the problem of the
Yes, right. Right,
existing art. You need not mention that
This
patent
particular-
document
yes.
particular because it is not relevant.
Yes.
Okay, because it is not solving the same purpose. Even if it is solving the same purpose, it is not using the same components. So if it is not relevant, there is no need to add. Because then you cannot say that, okay, I have developed from that prior art to this.
That's why we say relevant
prior art should be
Yeah.
there, and whatever you are developing, whatever your invention is doing, or the function of that, the purpose of that invention should be very clear in the specification. It should be,
Yes.
you should define it properly. You should. And you were asking about the do's and don'ts.
Yeah.
I would suggest that you should not add too much material in the background.
You are telling it from litigation point
Yes,
of view.
yes. Like even for the prosecution also, yeah.
Okay, you are talking about background. Yeah, I
So
thought description.
background part. So we have 6-7 parts: field of
Yes.
invention.
Yes,
and
yes, right.
Field should also
Background should be short, concise, and
Concise,
clear.
concise.
Yeah. You should not comment on any
talk about the problem statement which is
Generic.
existing, and
Generic.
why it is having so much of problem, and that is why you came up with this invention.
It need not be that
It not will
descriptive.
be very descriptive, because all effort you should put in your invention rather than saying what was not there in the existing art. Let's focus on the current invention which is there in your hand, and you have to enhance it. And sometimes I have also seen they talk about prior art in the description.
Yeah.
Yes.
That's
So
big mistake.
they describe that, okay, we have done this, and it is improving over the. So all the improvements come in the description part. That is fine. Okay, you are talking about advantages. That is fine. But the how part is missing.
Yeah, and that is the most
Yes.
important part of the
The what
description.
part remains, the advantage part remains, but how. Another example I would like to give, in the software and AI related
AI.
inventions, there is a term called analyze. The processor is configured to analyze blah blah blah. So how, okay, you have configured. What is this analysis? What is happening in this analysis?
How
you
it is
you just
happening.
cannot go away with this term. Okay, it is facilitating to do so and so. How it is facilitating? These terms are very good: facilitating, analyze, analysis. But you have to talk about this analysis. You have to define this analysis in your specification.
So, Saltanat, before we let you go, let's play a very quick, short, rapid fire round or segment. Just 4 to 5 questions. No overthinking. The very first thing that comes to your mind. So, ready?
I'll try my best.
Okay, brace yourself. If you have to define IPR in one word, what it would be?
I think ownership.
Okay.
Yeah.
And if you have to define patent in one word, what it would
Patent
be?
is exclusivity.
Okay.
You get exclusive rights for it.
If you have to redo and undo one career move in your IPR career, what it would be and why?
Oh my God. Redo one career move.
Yes.
I'll join my first firm.
Wow.
Yeah.
Krishna and Sarah.
Krishna and Saurashtra, yes.
Wow.
Because the work culture over there
Yeah,
They mentored.
we have
Yeah,
enjoyed
we have
time
enjoyed our
there.
times.
They like
Yes.
all young crowd,
Yes.
and we enjoyed
We
and we
enjoyed
worked
new
and
projects, new
yeah.
people, new team.
If you'll
And
ask me, my answer would also be the same.
we
I
all
think.
we all we are here because we were there.
Yes.
Yes, so
Absolutely.
we were mentored very correctly. I I was given chance to study many courses and
Yes.
go to
Yes.
learn drafting
Yes.
and
And undo.
undo. Undo, I don't want to undo because it's a process I have grown with.
Yes.
Like you make
Okay.
mistakes,
Got it.
you make bad decisions, you because of certain circumstances, but it makes you learn.
And
It gives
grow.
you life lessons, and you learn from it, and you become more strong. You
Yeah.
evolve.
Yeah.
So life is not only about good
Yes.
things, but it has to be, it's a mixture of
Yes.
both
True.
phases, good and bad.
True.
Yeah. So
One memorable pattern project that you handled, which was specifically or particularly challenging as well as rewarding.
yeah. So it was during my early days. Nowadays, because I'm so much, I have so much of experience.
Experience.
So every case is like another case for me, unless it results in very drastically and you don't get the result you were expecting. So during my initial days, we were introduced to a U.S. attorney who would send us some assignments and to write claims, and they would send
It was medical
devices. That client, if you remember.
Yes, yes.
So they used to send us various projects, and we all used to work on it. And there was one draft. I remember, I remember that number. I would not sit.
Yeah, you cannot specify it here.
So it was like 1111. This number was there, and with that prefix of that company, who drafted.
So and
Suppose
so.
ABC 1111. Somebody pointed at me that Saltanat had drafted. Congratulations! And when he congratulated me, I was so happy. I cannot forget that
Moment,
Yes.
yes.
So that is very memorable. I still
From U.S. attorney, right?
From US attorney, yeah.
What was? Okay, we cannot.
we cannot discuss specify
yeah,
this thing.
Correct.
But yes, it was from US attorney. He was very happy to receive my draft because he had to work very less on that draft. Usually
That attorney, I think, was very experienced.
very experienced attorney. And
He was having 20-25 years
Yes,
of
yes,
experience,
yes,
right? Yeah. One aspect of Indian ecosystem that you want to change or improve.
I really wish, I handle both. I handle prosecution for various countries like EP, mostly US and mostly Indian prosecutions. So I really wish how US office action
Is
is
very
issued
detailed.
and
Yeah.
is very detailed. They provide rejection. They provide reason for rejection. If they are rejecting due to 101, they will tell you
Specify
this claim
why.
language is not so and so. This is not supported by your specification.
Even each and every element they map.
Yes, they
Yeah.
read each and every section, the field or background or whatever, the claims, the specification, description, even the antecedent basis, and if you have described anything in the specification, but it is not, the reference numeral is missing in the drawings, they even highlight that.
Yes.
They ask us to improve that. They ask us to correct that. And sometimes they even provide examiner suggestion.
Yes.
Examiner amendments.
Right.
So they really are they are very active in
They are very detailed and descriptive in their
pro-allowance.
rejections.
Yes.
Yeah.
And
It helps.
yes, so it helps us, prosecutor like us, or
To argue, or
to argue
present our-
or to prepare the response
Right.
accordingly.
Right.
But what happens with the Indian examiner? They just mention the prior art number.
Yes.
and whole document. They do not mention why they are thinking whether this is
destroying
novelty
novelty.
or whether this is making
Obviousness.
it obvious. Okay, general state of art is understood, but if you are quoting any prior art
Right.
reference,
Right.
you must have read that prior art reference.
Correct. So you
And
need to
then you
map.
should analyze, you should map it. Okay, because of this paragraph, I am rejecting
Because
this
of
claim.
this so and
Because
so
of this,
element
so and
maps
so.
to this.
Sometimes they just do a keyword search. If a server written in my specification
They
is
just
found in any
yeah,
other
right.
specific in any patent literature or non-patent literature, they will quote that. They will refer to that. They will cite that. Every two inventions cannot be same. You have to point out what rejection you are. If you are talking about novelty, why you think so? Why it is destroying novelty?
Which element is
Which
mapping
element is
to
mapping?
mapping?
Okay,
Yes.
why? So that part is missing. So I really want that Indian examiner also do a thorough reading of the patent specification, do a thorough research, and pull out relevant documents, little relevant documents. Sometimes the documents are not at all relevant.
Yeah, and the rejection should be very
Should.
detailed
Yes.
so that it makes sense.
It makes sense,
Yeah.
and it makes the other person also to respond it properly.
Yes.
Sometimes because the question is not understood and what the examiner is wanting from us
Is not clear.
is not clear. So the response also goes like
Yeah.
a very general response. It is not a
Yes.
specific response.
Yeah.
And then the objections is clarified further during the hearing. And then again hearing, we have to provide a file or written submission. So all these process are
fros.
too much.
Yes.
If I compare with the USPTO and Indian Patent
They
Office,
are very good in rejecting in their rejections, because their rejections are very detailed.
very detailed.
Yes.
If they are
saying this is not novel, they will say why this is not novel. Your so and so component is mapping to so and so component of
Yes,
the
yes, yes.
prior art. So it is very easy to just
Very,
go
yeah.
through and reply it like very to the point reply. Yes.
Although I
agree with you
So
on that.
I have seen in many FER responses, like I keep on studying the granted case, the recent granted cases. I go to the prosecution and read what examiners are where had objected and what response had been shared. So the response are really good. Like patent attorneys, they really put a lot of effort in providing the response. They compare the figures. They provide a table.
Actually, they do examiner work also.
Yes.
So we are doing inventors'
Yes.
work. We are doing
Yes.
examiners'
So-
work as well.
So
yeah.
they don't know what the examiner is asking. So they
Yeah,
provide
it's not clear.
everything.
It's
So
very
it's
generic
generalized. It's
rejection.
very generalized that this is under 21J.
Yes,
It is not
rejected
novel.
under so
It is not inventive. And then I've also seen examiners saying that this invention is lacking unity of invention. In most of the cases, there is a single inventive concept, but the examiner points out that it is not because of the claim language or again.
Again, why?
Yeah.
Why you are rejecting?
Why you are
it?
rejecting? Why you are thinking that this is not
unity
a
of
single invention? Why you think that it is not a single inventive concept?
So that will really help.
Yes.
Yeah. Right.
And sometimes the FER, the inventors, they are not able to understand what the FER is talking about.
Yes, right. That is true. They
Yes.
don't understand.
So first you have to educate them. You have to provide a thorough review. You should not just say that, okay, your FER has been issued. So what are the chances? What would be the strategy that you should also provide, especially if you are the drafter of the specification.
Okay. So, Sultanat, which part of or which aspect of patent work you enjoy the most? Drafting, prosecution, litigation, working with innovators, inventors, research and development, analytics.
I
Which
think
part?
I think I would say drafting,
Yeah, you
because
love drafting.
it gives me more scope. Like I can write the way I want. Once it reaches the prosecution stage, I am
You are
limited.
restricted
I am
to-
restricted to that specification, whatever is disclosed. But initially, I can put all my thoughts. I can
You
see.
get your freedom. You have
Yes.
like white canvas in front
Correct,
of you,
correct.
and you can color it the
Correct,
way you
correct.
want.
Correct.
I can totally
So I
understand.
can play with words. I can put.
Correct.
Sometimes I draft too many claims, and then I check whether this is which one is more robust, which one is more, and then I decide. Like I always draft more number of claims and then refine it further. So I get to write more, I get to think more. But during the prosecution is also good,
Yeah,
because
yeah.
that
You
is
have-
also very challenging.
Yes,
That
it
is very
is.
challenging.
Yeah, it is,
Yeah.
because you have to prove how invention is not obvious with the information that you have, like
Yes,
restricted information
Yes.
that you have. You have to make your arguments based upon that particular information only,
Yes.
and that is also not
Yes,
easy.
And
job.
especially when you get objections like 3K, 3M,
Yeah.
you put a word like presentation and the examiner would cite that rejection.
In US PTO, even like when you are drafting, you have to be careful that it should not go to particular art unit.
Correct,
Like
correct.
3500 art
36
unit, 3600
series,
art
yes,
unit
yes.
is like, so which all word to avoid, because we don't even know what algorithm they use, which all sections they take to decide on art unit. We are not aware of that. Many people say they take title of the invention, field of the invention, and abstract. Many say they take claims. Some algo they have wherein they take these sections, they extract some keywords, and then they decide which art unit it will go to. So to draft, considering those things also, it is like very
Yeah,
difficult.
you should be very careful.
Very careful. You have to be
should
very
not-
careful.
yeah.
How to avoid art unit
to-
3600. So, you
should-
cannot use words like business.
That would be a
and all.
different podcast if we
Yeah,
talk
I know.
about
Actually,
101.
I feel we have talked much about prosecution.
Yeah,
in
this was a very general.
Yes, in general.
Even if you go into drafting, there are certain strategies, different strategies for different inventions. You cannot put all your cards in, similar cards in all your drafting assignments. So you have to think differently. And that what will help you read a lot of FAR responses and your office action responses easily available on websites of USPTO and Indian Patent Office. So that would help you to understand how the examiner thinks, how the rejections comes, what you should not write to avoid certain rejections. So this really helps. You should keep on reading.
Thank you so much for being a part of our podcast and enlightening our audience on patent drafting. It was truly, truly insightful. And I hope it must be helpful for the audience or for the professionals involved in patent drafting. And to my audience, viewers, watchers, listeners, thank you so, so much for tuning into Let's Talk IP. Please remember that each and every idea has power to change the world, if and only if, that is IFF, if it is protected properly. And that's why I say it is high time to know IP, very high time to think IP, and very, very, very high time to talk IP. Until next time, stay tuned and goodbye.